Good morning.
Good morning, Ms. Sandridge.
Morning, Your Honors.
You are all set. Everybody's in the courtroom. You may proceed. Just let me know if you want to reserve any time.
Thank you. If it may please the court, my name is Halla Sandridge. I represent Lee Memorial Health System, now known as Lee Health. I'd like to reserve 5 minutes for rebuttal.
Very good.
This appeal comes to this court on a denial of a motion to dismiss based upon Lee Health's sovereign immunity defense, and it involves really a simple legal issue. Did the legislator intend to waive sovereign immunity for amounts that are owed by statute but collected by a legislative process that was found unconstitutional over 20 years after enactment? There is no waiver of sovereign immunity that exists under tort or contract theories in this case. The class plaintiffs seek economic damages only, but they do not allege a tort seeking personal injury, property loss, or wrongful death for which there is an express legislative waiver. Nor does the class plaintiffs lawsuit involve an express written contract for which the Florida Supreme Court has found a legislative waiver. Instead, the class plaintiffs assert an unjust enrichment theory. And they base this theory on the fact that Lee Health collected medical bills through a procedural process declared unconstitutional by this court and the Supreme Court. Those lawsuits were filed by insurance companies that challenged the lien statute that allowed Lee Health to lien insurance proceeds. But, and this is very important, neither this court nor the Florida Supreme Court found the underlying charges for medical services illegal.
Can I ask you a quick question on that point? If you pay sums, are you required to pay the sum under protest and then dispute the charges that the statute is unconstitutional in order to retain your right to seek reimbursement down the road?
Yes, Your Honor, that is one of our defenses that we raised on motion to dismiss, and the lower court determined that there were factual disputes, and so that issue was not resolved on a motion to dismiss, but that is one of our legal arguments.
Well, many of us have handled these type of civil actions where you've got the payment, the rendering of medical services, and you're going to have a lien that has to be satisfied. So here we have a claim that does not challenge the legality of the bill as being usurious or unconstitutional or anything like that. And most of the time you end up paying less. Now, we don't know what the plaintiff paid here, but they allege that they paid it. What did they pay? Did they pay the amount you claimed, or did they pay less, or was it negotiated? What?
So the record does not show, Your Honor.
Okay.
We have not gotten, I know the answers, but the record does not show.
Okay, so let's just take Lee Memorial out of the equation. Let's just say it's any hospital that doesn't have this ordinance or law. They have a legal entitlement to be reimbursed for medical services, do they not?
Correct.
So how is this unjust enrichment to any entity that provides medical services?
It's not. And that is the important distinction here, is that they are not alleging, their unjust enrichment claim is not based upon the concept that they don't owe for the medical treatment that they received. Their argument is based upon this idea that the funds were obtained through a process that was later declared to be unconstitutional. So unlike all the other cases that they rely on, where the underlying amounts couldn't be owed, these amounts are owed, and they have not alleged otherwise. And that is the big distinction in the sovereign immunity defense that we raised. So,
Yes, is it your position, though, had they alleged in more detail the unjust enrichment aspect that Judge Sleet has brought up, are you still arguing that sovereign immunity would protect the hospital from that lawsuit?
Yes. If they alleged that, let's say they didn't like the amounts that we charged them.
Let's say they claimed the bill was for a different procedure than was actually rendered, a much more expensive procedure than what was actually rendered. And there's a mistake in the billing, and the hospital doesn't want to correct it or refuses to correct it. Would a sovereign immunity bar that claim?
Yes, I think sovereign immunity would bar the claim that they're making now. if you're saying, let me go back.
Let me finish. Let's use my hypothetical. If the hospital, and I understand this is a hypothetical, if the hospital sends out a bill that is incorrect for whatever reason, it's mistakenly sent out, but they end up getting paid, maybe the patient pays it without paying enough attention to it. Are you saying that sovereign immunity prohibits the patient from seeking recover of the amount that was paid in error or that was billed in error?
No, if under that scenario, no. The parties have a contract. They would have an express written contract, and so sovereign immunity.
Let me interrupt. Is a bill in and of itself a contract?
I don't think the bill is. I think the admission agreement is.
And do we have the admission agreement in this record?
We don't. They did not put them in.
So again, I want to use my hypothetical, and I want to make sure that we're on the same page. And if we're not, then I want to understand why. Are you conceding that in my hypothetical, if there was a claim of erroneous billing and overcharges and inadvertent payment of overcharges, are you conceding that sovereign immunity does not apply to that?
It would apply if there's no written contract. If there is a contract, an express written agreement, then sovereign immunity would not apply.
So there would be no unjust enrichment action under those circumstances. It'll have to be, well, it's a tort claim under 768-28, and it's barred.
So there would be two potential claims there. If they brought an action because they said that we unreasonably billed them under the admissions agreement, then what they would have is some sort of express breach of contract claim for which there is no sovereign immunity. The other alternative, Your Honor, there is no tort claim because they're seeking economic damages. So it would have to be some sort of breach of contract claim, which they have not alleged because they have never attacked the appropriateness of the medical charges. So the hypothetical, Your Honor, that you are putting before us is not one that has ever been raised. They are on their second amended complaint. They have never challenged the appropriateness of the medical charges. The medical charges are offered by law.
That's why I said it's a hypothetical. I wanted
yes, Your Honor.
If we were to rule in your favor and we write an opinion on this, we need to make a determination, how far does sovereign immunity go? And I recognize that you're acknowledging in certain circumstances, sovereign immunity would not apply to an unjust enrichment claim.
Absolutely. The Bill Stroop case says that sovereign immunity does not apply to prevent an unjust enrichment claim when there is an illegal charge that should not have been made. It was made in violation of a state statute. That is the Bill Stroop case, where the state law prevented local governments from enacting statutes or ordinances that allowed them to charge contractors. And Miami-Dade County did. And they started charging contractors. And the third DCA allowed a refund lawsuit because it expressly violated the state statute that prohibited the county from doing exactly what it was doing. In our case, it's the exact opposite. We followed the statute, the act that allowed us to make these charges, really required us under Section 11 to charge patients reasonable rates for the services that were rendered, and allowed us to go forward with a lien to collect the charges that was later found to be unconstitutional. So that separates our case from all the other cases that have been cited by the plaintiffs. Their cases are cases that have all involved a tax, a fine, an occupational license, an illegal impact fee, items that were prohibited under Florida law. We don't have that here. And so under such circumstances, I would suggest that it makes sense that the judiciary would find that the legislator intended a legal remedy for funds that the legislator prohibited the sovereign from collecting. But unlike these other cases, Lee Health did not ignore the law. It operated in good faith under a valid legislative enactment until it was declared unconstitutional. And there's simply no case in Florida that finds a legislative intent to waive sovereign immunity to allow a refund lawsuit when the funds collected were owed by the statute. So because there is no such case, this court would have to infer that the legislator intended to waive sovereign immunity when the sovereign collects payments legally owed through a legally defective process. However, waiver of sovereign immunity must be clear and unequivocal, and legislative waivers of sovereign immunity must be strictly construed. So given the facts of this case, that these funds are permitted by state law, there is no basis to infer a legislative intent to waive sovereign immunity, and therefore we contend that the cases upon which the magistrate and the trial court judge relied. So we ask this court to reverse the trial court order finding the legislator waived sovereign immunity, to permit a lawsuit for refund of medical expenses legally owed by statute. If there are no questions, I'd like to reserve my time for rebuttal.
Very good. Thank you, counsel. And Mr. Ferraro.
May it please the court, my name is Joshua Ferraro, and I'm appearing on behalf of the appellees in this case. The appellate has restated its position in multiple different ways, in multiple different forms, including its brief and oral argument. But at the end of the day, the overarching issue is whether or not sovereign immunity would bar a claim for a refund when there was an illegal or unconstitutional extraction of money from one of the citizens.
What was illegal about it at the time they filed the notice?
At the time that they filed the notice, the law had not been found to be unconstitutional.
Correct.
That doesn't mean that it wasn't unconstitutional.
Well, let me ask you this question.
Yes, sir.
A hospital provides medical care to your client. Are they not legally entitled to pursue reimbursement?
Yes.
Regardless of sovereign immunity?
Yes.
Okay. You do not challenge the method about which they went about doing this, because you, in your complaint in paragraph 13, alleged that you felt you had a legal obligation to pay exactly what they were asking for, which just screams deck action. It screams deck action, but you didn't do that. You don't challenge the amount of the bills at all. You don't say they're illegal. You don't say the hospital's not entitled to them. You take what we did recently and saying it was an illegal method of asserting a lien that violates private contracts, and now you're trying to apply that to something that happened years ago when it was legal to do it.
Well, if I can address that, Your Honor. First, when we plead the idea that we believe that there was a legal obligation to pay, the legal obligation arose from the lien. These were liens that were attached and served upon third.
Hang on a second. The
yes,
legal
sir.
obligation arose from the provision of services, correct?
Yes, Your Honor. However,
so the legal obligation didn't arise as a result of the illegal conduct. What your contention is that the illegal conduct let them collect the monies that were otherwise, at least based on these pleadings, that were otherwise due and owing.
There was an amount that was due and owing, and I believe that the general law is that a reasonable amount of medical bills is due. The mere fact that they issue services, provide services, and then provide a bill is not dispositive of itself.
Has the reasonableness been challenged in this lawsuit?
Not at this time, Your Honor, because that would be based upon an affirmative defense under the voluntary payment doctrine. And the voluntary payment doctrine, and this was discussed in the trial court, both in front of the magistrate and I believe in front of the trial judge, the voluntary payment doctrine is an affirmative defense that not only has to be pled but proven, because the defenses to that is whether or not there was coercion. And it would be our contention, if they were to raise that affirmative defense, that the use of a lien which attached to their entire settlement proceeds, which was served not just upon them, but upon their attorneys and upon insurance companies, was coercive in and of itself. And
And
essentially,
at the time the lien was served, was a challenge raised to the validity of the lien?
no, sir, not at that time. And it's our position with regard to the unconstitutional nature, because I believe Judge Sleep brought up the fact that at the time that this amount was paid, at the time that the lien was served, these had not been determined to be unconstitutional, at least by this court. However, unlike where a legislature later passes a bill and says this is illegal, now it becomes illegal going forward. But when the court determines that a law is unconstitutional, it was always unconstitutional. The Constitution didn't change. There was no new provision that was passed or inserted into law that made this unconstitutional. It was unconstitutional ab initio from the very beginning. And so what Lee Memorial was able to do, and of course, we're not going back to the beginning of the lien law because there is a statute of limitations, which was brought up by counsel. What they were able to do was to use this unconstitutional lien law in order to leverage a payment that they may otherwise not have been able to attach, either because they didn't have to go through the traditional judicial process, in which case the plaintiff or plaintiffs may have been able to would have been able to object to the amount and claim that the amount was unreasonable under the circumstances, or because they would have, there was an additional leverage here because they were holding on to the settlement proceeds that these people had already negotiated or been with the third-party tortfeasor. By using the unconstitutional means, they essentially used an illegal method of extraction in order to turn the wheel, in order to leverage the plaintiffs to pay the amounts that were owed. And that is the basis for the unjustment. The benefit that was conferred, because of course unjust enrichment requires that there be a benefit that's conferred and a circumstances under which is inequitable to allow them to retain that benefit. The benefit that was incurred was, I'm sorry.
Before the statute was declared unconstitutional, was there a method by which a patient could challenge the amount claimed and the lien amount?
Certainly, Your Honor. The patient could have filed a declaratory judgment action. They could have filed an administration, presumably, they could have, I'm not an administrative lawyer, but they could have filed an administrative action. That would all go to, and this is what was set forth by the magistrate and the trial judge, that would all go to the voluntary payment doctrine, which is an affirmative defense that we haven't gotten to yet. The only issue that's been raised by the pleadings, by the briefs at this point, is whether or not sovereign immunity would bar a claim for a refund to the extent there has been an illegal extraction. And it's our view that the vehicle that was used to make this extraction was illegal in and of itself, and therefore the extraction was. And I'd like to point your Honor's attention to, and of course it's not binding upon this court, it's a federal district court, but it is directly analogous, is the Parker v. American Traffic Solutions case. Because in that case, there was red light cameras that we still have throughout the state, but the ability to determine whether or not there was a appropriate fine was improperly outsourced to a third party. And it was raised that, hey, the defendants in these cases, they paid the fine. They voluntarily did it. They could have gone in and challenged it. They could have brought a separate action, administrative action. They could have gone to court on the underlying issue. And,
yeah, but let me stop you there,
yes,
because you're talking about a fine for an alleged traffic violation.
Mm-hmm.
You cannot ignore the fact that your client was injured and was treated at Lee Memorial. This isn't a traffic ticket. Lee Memorial didn't cite him for running a red light. Lee Memorial, I don't mean that facetiously, sir. Lee Memorial's doctors treated your client. They're entitled to reimbursement. You haven't even challenged the amount of the bill. I have a hard time finding that you're entitled to any refund whatsoever, because you're arguing to this court that you deserve a refund because of the manner in which they went about trying to recover what they were entitled to.
Well, if I can respond, Your Honor, let me use that as an analogy. There are situations, of course, and this is an analogy, of course, where a tenant may not pay their rent in a commercial building. And the landlord comes in and locks them out, and their business goes down the tubes as a result. That would present a viable claim for wrongful eviction, even though the landlord provided the service, they provided the dwelling, there was an agreement to pay for it. There is no question that the tenant is required to pay the landlord for the service, for the rent.
Yeah, but the
And yet
landlord affirmatively terminated the service. Lee Memorial just said, pay us what you owe.
Well, they didn't just say pay us what you owe. They asserted a lien under color of law because they're a political subdivision, and the implication of that to the person receiving the lien, we believe this isn't in the record.
Well, let me ask you a question just from an outside observer. If the hospital sent a bill, didn't say, oh, by the way, we're liening you, if you don't pay us, we're going to sue everybody, and the client just says, okay, yeah, I owe the bill, I paid the bill. How do we know that your client didn't just pay the bill because they recognize they owed the bill, as opposed to your assertion, well, I'm not going to pay this bill, but since you're extracting it from me, I have no choice but to pay it. So how do we know they didn't just say, oh, I owe the money, I agree? And my point earlier was, unless you pay under protest, how do we know why you paid?
Well, and I would argue, Your Honor, that we likely would not know. We will after the trial with regard to these particular clients, but we may not know with regard to every client. And that is why it's vitally important that the process for extracting payment, particularly under color of law, particularly by a government entity, be done in both a legal and a constitutional, which they're one and the same method, because there is no way to make that distinction on a case-by-case basis. What we look to is whether or not the process itself is constitutional, and we always try to hold.
You're saying as a matter of law, once this process is declared unconstitutional, any payment we made was an extraction as a matter of law.
Yes, to the extent that the lien was served upon a third party, and the payment was made by the third party, in this case the attorney, to Lee Memorial, there was an extraction as a matter of law, and the extraction was based upon an illegal process, an illegal benefit by obtaining leverage, by obtaining an extrajudicial means in order to get this. It deprived the plaintiffs and others similarly situated of the ability to do nothing and see if the lien holder would have come after them. Or not, I'm sorry, not the lien holder, but the hospital, which happens all the time. It provided it.
But you normally don't get this to a hospital. In other words, in this case, once it's determined the hospital is a political subdivision, which you don't dispute, then they're entitled to basically a presumption of sovereign immunity unless you can show a ground for waiver, such as a tort or something like that. And your ground for waiver is illegal extraction. Is that summarize it?
Yes, there is no dispute that this is not a traditional tort under 768, that there was no express written contract. We don't dispute any of that. But as the courts held in Stroop and others, this is essentially not just a typical unjust enrichment based on the contract goes wrong and there's some other issue. This is essentially simply seeking a refund of the monies that we pay. We are asking that the parties, and by the parties, I mean the plaintiffs and Lee Memorial, simply be placed back into the position that they would have been in, but for the illegal extraction. At that point, Lee Memorial is more than welcome and presumably would pursue that debt using the proper judicial means, and the plaintiff is entitled now with the money in his pocket that he would have had.
What do you mean by proper judicial means?
Well, as I understand it, the appropriate way to, absent the lien law, is they would send a letter or whatever means, but if it's not paid, they would file a lawsuit against the plaintiffs and say, you owe us this money. And it would go to court, and the judge would determine whether an amount was owed and whether it was a reasonable amount based upon the facts and circumstances.
Well, your client got the benefit of medical care, correct?
Absolutely.
And so Lee Memorial is entitled to be reimbursed. You keep calling that a benefit, but it seems to me your client got the benefit of medical care.
When
So
I'm
they're entitled to be reimbursed. Hundreds and hundreds of personal injury cases throughout the state of Florida. When the plaintiff disagrees with the lien, the judge resolves it. That is your avenue. This was not done here. You claim that your arm was twisted in some sort of way to where you were coerced and had absolutely no other recourse but to pay it. When you know full well, you go to the court when you disagree, and the court resolves it.
well,
I'm still trying to figure this out because you just don't like the method by which they did it.
it's not that I don't like the method. It's that
So even though we've
Yes, sir.
declared that unconstitutional, isn't Lee Memorial still entitled to recovery of those bills?
absolutely, but they have to do so through the judicial means, which is to, just as you would, and as any other creditor would do with any other debtor, file a lawsuit if the amount is not paid, establish the amount, not just entitlement to some amount, but establish the
So
amount.
you want us to keep this case going on and on and on.
Well, no, Your Honor, I would like simply a finding that in this case, on the only issues before this court, that sovereign immunity does not attach to a claim for refund where the money was legally extracted. And it would be our position under Stroop and the other authorities that the question of illegality is not whether the underlying debt was or was not legal. That's for a different process. The question is whether the process used to extract it is illegal. Just like, as I was saying, I'm sorry, go ahead.
Well,
No, you were gonna say something.
Dade County clearly violated a state law regarding general contractors. Dade County was charging a fee for them to be able to practice their profession in the county. That's against the law. Parker, the state, controls traffic violations, but they put the onus, or they spread the burden to a third-party vendor to issue traffic tickets. And they would not only profited, but the third-party vendor profited. I just can't see any application to your situation.
Well, the similarity is the fact that although the underlying debt in Stroop was void, and all the underlying debt in Parker was not void, it was a traffic ticket. The question is, how do we allow the government to use a means to extract payments, which this very court found to be unconstitutional, meaning illegal. It was an illegal use. If I owe money to, well, I won't use myself, but if Tony Soprano owes money to, is owed money, he can go to court and get it, but he can't use extrajudicial means. He can't use an unconstitutional or illegal means in order to get it. It's the process matter. It's not a question necessarily of procedural due process, but the idea still renders itself. It has to be not only substantively correct, but particularly where it's the government, you have to do so in a procedurally just manner. And if you do so in an unjust manner, and by unjust, I mean unconstitutional as determined by the courts, then you have to go back to the beginning and start over. And I understand that that could potentially lead to this going on and on and on. But I think it's important that the court not allow the government to use unconstitutional means in order to repayment. And then after rebuffing them and say, this is not constitutional, you can't do this. Then saying, but there's no remedy. There's no ability to go back to the beginning. We're going to say going forward, but to the people who have suffered from the unconstitutional conduct in the past, there is no remedy, and we're sorry that it happened, or we're not. That is the basis of the case. The benefit that was conferred, this is at the end of the day a claim for unjust enrichment. The benefit that was incurred on Lee Memorial Hospital System was the ability, wasn't the money that they received. That may or may not have been unjust. That may or may not have been the correct amount. The benefit that they received was the ability to use an unconstitutional means in order to short circuit the process, in order to determine whether or not, in order to obtain the money in a way that they may or may not have been able to get it otherwise.
So let me ask you a silly question. Yes. If I'm the trial judge and you win this appeal and Lee Memorial has to do the refund, was to prevent them from running to the circuit court and saying, Judge, we want to pay this refund into the court registry while we litigate that we're actually owed this money.
Mhm.
Would that be an acceptable solution?
Yes, absolutely.
So then what is to be gained by you getting an opinion from us to order a refund?
Well, again, the opinion today is not to order the refund, it's to declare that the mere
I'm sorry.
request for a
Let's
refund.
rephrase the question then.
Sure.
So what's the benefit to you? Is it all about attorney fees, or is there some other benefit
No.
that I'm not seeing?
Absolutely not, sir. We don't know what action Lee Memorial would take. Perhaps they would go and they would litigate every one of these cases. Perhaps, but I think, I mean, obviously it's not on the record, but a lot of hospitals write things off. A lot of hospitals reduce things. Things are negotiated, and they're negotiated based upon a lot of merits. One of which is collectability, whether or not
Okay.
there's a
So I mean,
lenient
there's some leverage, benefit of some sort of leverage.
absolutely.
I just was confused where this is ending up, but I can see your point. Thank you.
Thank you, Your Honor.
Mr. Ferrer, just to let you know, you've got about 30 seconds left. So if you want to try and
Okay.
hone in on your final points.
Well, I appreciate all of your time. Again, our position here is not, and I understand what each of you has said, but our position here for purposes of this argument is not that, the underlying payments were illegal. It is that because they were illegally extracted, the amount of those payments could not be litigated in the traditional and appropriate sense. And that conferred a benefit upon Lee Memorial, which was an illegal process, an illegal extraction, which should entitle at least the waiver of sovereign immunity, allowing us to proceed. Thank you.
Very good. Thank you, Mr. Ferrer. Ms. Sandridge, you have your 5 minutes for rebuttal.
Thank you. So on the issue of benefit, the reason they want this suit to go forward as is remember, this is a class action. If we have to get into individual issues about what each party did, whether they paid a full amount, a lesser amount, amounts were written off, what was reasonable, what was not reasonable, it destroys their class action. So they pled it this way because they want to continue the class action. Number two, they could have questioned reasonableness in response to our lien. The statute specifically provided that although a presumption was created that our amount was reasonable, they had the ability to come in under the act and challenge that. They didn't. I will also note that in one of the lawsuits that was before this court, the all-state appeal, this court could take judicial notice of the records. The insurance company did say, we want to challenge the reasonableness. So that was an option that could be done. Another point.
One more question. If this becomes a ruling in his favor, the money has to be, the statute declared on, it's an illegal extraction, for example, then the hospital has to litigate payment. Wouldn't they put the admission documents in evidence? And isn't there something in the average admission document dealing with attorney fees? If we have to sue you, you got to pay our fees. So isn't this about fees on some level?
On some level, it is going to be about fees. I have to take a look at the admissions agreement again. I believe there is an attorney fee provision, but it's
That's
not in the
okay. You
record.
don't have to
Thank
answer.
you.
It's more of a hypothetical.
Two other points that I think are important. Parker, upon which they rely. There, the city of Hollywood, its red light program, its ordinance violated the plain language of the Traffic Safety Act. So here again, what you have is a local government violating the law, enacting an ordinance that violates what the legislator has said you cannot do, and then attempting to collect on it. We don't have those facts here. And what seems to get lost in the appellee's argument is why we are here. We're here trying to figure out, did the legislator waive sovereign immunity to allow this type of an unjust enrichment claim? And there is no law other than the cases in which the local government violates a legislative enactment that permits this type of a conclusion that the legislator intended that there would be a remedy. I submit to you that when the legislator enacted both a process and a rate that we followed, that the legislator did not intend to waive sovereign immunity to allow a party to sue us for fees, which you have heard today, they agree are owed. So for all of those reasons, we believe that the trial court and the magistrate erred in concluding there was a waiver of sovereign immunity, and we would ask this court to reverse on the limited facts of this case. Thank you.
Thank you, counsel. Thanks to both of you for this interesting argument. We appreciate it. And that will conclude this case. The next case is Murphy Auto Group versus Department of